You logged in as published writer.
Oh, yes.
Okay,
let me
that's fine. I'll let you in now. We don't allow observations in Zoom. They have to go to YouTube. So let me let you in, okay?
Okay.
Okay. And then do you have a camera?
I do.
There. Okay. All right, perfect. So I know when we were here last, I had given Ms. Quinata some additional time. I know you had asked to speak with counsel. I haven't seen anything, so why don't I start with you on your ability to obtain counsel for today?
Sure. I decided, I already did everything that I needed to do.
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year, and I took full responsibility of everything. So I did want to say that on record.
Okay.
And then...
All right, guys, today kicks off a full week of courtroom chaos, and we're starting strong. This case isn't just about property, it's about entitlement colliding headfirst with reality. What looks calm on the surface quickly reveals a storm of false confidence, shaky paperwork, and a person who believes belief alone can replace the law. From the jump, this hearing feels less like a dispute and more like an inevitable collapse.
I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already. And Elazar signed that. And he also did a warranty deed.
And
so I'm not exactly sure.
What was the date that was filed with the auditor?
I have... Getting older. Let me put these fancy bad boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork. Okay. I am a single mom, and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox, though. But there was nothing to do with her name, to the best of my recollection, on it, nor Mr. Jackson's interest conveyed to Ms. Quinata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs is, does the person have a clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants in order prohibiting the defendants from taking, damaging, moving, or selling any plaintiff's property, restoration of any personal property that's already been taken or damaged, and then authorization for law enforcement to enforce the ejectment order.
The woman at the center of this case isn't loud or explosive at first glance. She's composed, soft-spoken, and confident in a way that feels rehearsed. But seasoned courtroom watchers recognize the pattern immediately. This is the language of pseudo-legal thinking, half-understood rules, internet theories, and paperwork that looks official but means absolutely nothing once examined under real legal scrutiny.
Clear right to possession. Plaintiff is the clear sole legal owner of the premises, pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 233-002-4408. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never had paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home.
The property itself is no mystery. A final divorce decree awarded it clearly and exclusively to the plaintiff months ago. No shared ownership. No gray area. No secret loophole. Yet despite that clarity, the defendant stayed behind, occupying the home without permission, without rent, and without any legal standing, turning what should have been a clean transition into a full-blown standoff.
She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing, gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns about the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025. But failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and has still failed to do so or show any indication that that's their intention. At this point, we believe that the injunctive relief is appropriate as plaintiff has clearly satisfied all 3 factors: the clear legal right to possession as the sole owner, that she does have a well-grounded fear and immediate invasion of that right. There's continued injury resulting from defendant's unlawful occupancy of the premises. And courts may act to preserve the status quo and to prevent loss or damage during litigation. So we're requesting the courts to grant this preliminary injunction, to grant the order ejecting the defendants from further damage. And I did want to touch too on the bond requirement for Court Rule 65B. So it does require a bond unless it's waived. We would just simply request that the court waive the bond, but if the court...
The plaintiff's attorney doesn't waste time. She lays out the request plainly: a preliminary injunction and immediate ejectment. Not eviction, ejectment. That distinction matters. This isn't removing a tenant with rights, it's removing someone who never had them. The argument is methodical, structured, and devastatingly simple. Ownership is proven, harm is ongoing, and delay only makes things worse.
Inclined to issue one that it would be a minimal bond of just $100 due to the two main factors of there's a lack of lawful claim or tenancy of ownership or ownership by the defendants. There's no credible risk of this being a wrongful action at this point. And also we would reiterate a request for fees and costs associated with this action. So to sum up, we are just requesting that the court grant the order for the preliminary injunction, ejecting the defendants from the property immediately and enjoining them from interfering further with plaintiff's property or damaging it, and to authorize law enforcement to remove them immediately.
Okay, so Ms. Quinata, go ahead. I did review your response, and I did review kind of the preliminary argument that you have, or kind of the main argument, I should say, regarding adverse possession. I know that you're not doing this without an attorney, but typically adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free. Go ahead.
Okay. First thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but I've been there for almost 3 years, so going on 3 years. I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have...
The court hears about missing property, unexplained damage, frequent police visits, and animals left in troubling conditions. This isn't just a legal inconvenience, it's personal harm piling up day by day. The plaintiff has been locked out of her own home, forced to live elsewhere, watching her property deteriorate while someone else plays pretend owner behind her walls.
That I was reaching out to her, and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department, because they had taken some reports and had said, we seen a notice on the door, and they actually verified that there wasn't public notice on the door and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think in September, whenever their divorce was, I started reaching out to her, and all I got was, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns the house. I go, I know, but I'm just trying to communicate with them. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I was never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I had to do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Eleazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case, like today, is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then oh, that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? And so then I actually submitted the information.
Then it's the defendant's turn to speak, and the tone shifts instantly. What follows isn't a defense so much as a rambling explanation stitched together from buzzwords and misunderstandings. She claims adverse possession, mentions maintenance work, references unsigned leases, and insists she tried to do the right thing. But none of it aligns with the actual legal requirements she's invoking.
To the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099A with them. And then that's when I asked Elazar. He said he didn't want anything to do with that house. I said, okay, well, will you sign? I didn't know what kind of deed to sign from him because I couldn't get a hold of Annette. And so then Elazar had signed all of them pretty much because I put them together. I was like, I don't know, this is what the auditor's office is asking me for, but I did pay on the mortgage and the taxes. I did the last 2 years of taxes. I paid those off, and then I also did the mortgage. I have an agreement with the mortgage company. So she was already at default before I even made this decision or even decided to go into this position. So that's where I panicked, and that's where I started asking around and doing a little bit of research. And so that's where I'm at.
You're paying the mortgage every month?
No, I paid it off with my trust fund. It is, hold on. Let's see. And actually it was more than what they hold on it. Working in this little tiny spot. So hang on. It was paid on, of course I got a really bad copy. I'm gonna have to pull up the original document because this is really light, the one that I submitted. But if you don't mind waiting for just a moment, I can just grab my bag and pull it out. If you'd like me to grab that and tell you the date that I paid it.
Yeah, that would be helpful.
Okay, hang on just a moment. I dropped my box right before we started this, and it was with my paperwork, but the copy that I have, the hard copy, I just can't read the copy that I made you guys.
There's a 1099 that's of poor
it's
quality.
12/24/24. Sorry, I just got it.
December of 2024.
Yes.
Things unravel further when finances enter the conversation. The defendant claims she paid off the mortgage using a trust, pointing to forms that look official but don't function as proof of payment. The judge presses for clarity, and suddenly the confidence fades. Dates blur. Numbers wobble. Documents are unreadable. The story starts contradicting itself in real time.
And did you pay the $20,000 amount, or how much?
No,
did you
I paid $487. Wait, 400. Can't even read it. $418.79. I have $79.42. And then I also paid the taxes on it, and I can grab that.
So tell me the mortgage amount that you paid in total.
$418 and $70,000. Oh no, $418,079.
Okay.
Yeah.
Okay, and Ms. Radecki, your client does she agree with the fact that the mortgage was paid off?
No.
No, she does not. Okay.
That is news to me.
And I don't have proof of that in the file, Ms. Quinata. Do you have a document there that shows?
It was on the 1099 because I had to file this with the IRS, and it's submitted as an attachment.
It's
attachment H.
I understand. So what I was telling you is you did submit a 1099 to us, but it's of such poor quality that none of the numbers are readable.
Okay.
It appears to be in handwriting. So the title of it says acquisition or abandonment of secured property. Right. That's not a receipt from the mortgage company tells me that they've received payments.
I have a V and a B and a D, 10 and 8, all of those. Which actually so I've been talking with Freedom Mortgage, and somebody had submitted that some other mortgage had the deed, so I confirmed with Freedom Mortgage, and they were like, no, we still own the loan.
Clearly we're aware that in September of 2024, in a final divorce decree, unlike what Mr. Jackson submitted to the mortgage company, and clearly just a couple weeks.
Here's where the courtroom temperature spikes. The mortgage company still holds the loan. The deed was never transferred. And the paperwork filed with the county tells a completely different story than the one being told under oath. The judge's patience thins as inconsistencies stack up, each one louder than the last.
To go to Cowlitz County, the divorce decree did not just state that Ms. Jackson was responsible for the payments. It stated that she was given the property.
Yeah.
And I'm not. Well, hold on. So she was given possession of the property, and he was mandated to leave the property. And so first and foremost, I mean, I have some concerns about what's happening behind the scenes with Mr. Jackson towards this property that he is telling state, county agencies that he has the right to this property. He does not. And you now have received through this lawsuit proof of that. You have not been in the property long enough to obtain it by adverse possession.
Okay.
Even if you had met all the other factors, you're not even close, frankly, timeline wise.
Right.
So there's no question in my mind that a preliminary injunction is necessary in this case. The only question for me is if a mortgage in the amount of $418,000 was paid,
right,
then I would be requiring a bond of more significance. And so I guess let me hear from Ms. Radecki first, but we need to figure out if there's been $418,000 paid towards the house. Ms. Radecki, I know you've already said kind of this is news to you. What do you want me to know?
So, Your Honor, it's interesting because Ms. Kanata claims to be a tenant, yet she's also simultaneously alleging that she's paying off $400,000 to a house that she very much admits is not hers. So that information and the inconsistencies between that in itself is troubling to me. And I think that her having submitted documents and pleadings to her for both of her claims to the court is also concerning.
The court makes it clear, adverse possession doesn't even come close to applying here. The timeline isn't long enough, the conditions aren't met, and the divorce decree leaves zero doubt about ownership. What's left isn't a misunderstanding, it's a pattern of misrepresentation that the court is no longer willing to overlook.
You know, like I said, that doesn't make logical sense. We have no proof other than her words today that she paid off this mortgage. And again, so I would just request that the court not take that into consideration, or at the very minimum, I guess, require a $100 bond rather than waiving it, because again, we just have nothing further to substantiate the fact that she apparently gratuitously made a payment of over $400,000 to a house that she knows is not hers and is not going to be hers. It was officially granted to Ms. Jackson.
So Ms. Quinata, I don't want you to get the mortgage company online. That wouldn't be admissible here right now anyway, so don't do that. Here's what I'm going to do. I do think, again, I'm going to grant the preliminary injunction. I'm going to set this just 1 week before I sign that order, though. Ms. Quinata, I'm going to give you a couple days to file with Ms. Radecki by Friday proof that you've paid off the mortgage on the house. You personally have paid off the mortgage on the house. I want you to file that with Ms. Radecki in the court. And if we get that, and I agree that you've paid it off. I'll set the appropriate bond, but I am going to sign a preliminary injunction. I find that all three factors are met. There is no viable defense to ownership of this property. And I'll tell you again, I'm very concerned that there are acts of dishonesty, to put it lightly, that have happened in the last couple of weeks with the documents that Mr. Jackson and you have filed with Cowlitz County. And I'll tell you specifically what I'm referring to.
Sure.
You're here in court telling me that you paid $418,000 to the court.
To the mortgage company.
Or to the mortgage company, thank you. I misspoke. But in the documents that you filed with the court on the quit claim deed, you stated that the property was gifted to you and you paid nothing for it. And so no excise.
I didn't know what to do.
So no excise tax. So if you bought the house for $418,000, the things that you're saying to Cowlitz County and to this court are inconsistent and probably, I would say, fraudulent.
The ruling lands hard. The preliminary injunction is granted. The ejectment is coming. And the judge doesn't mince words, openly expressing concern about dishonesty and potentially fraudulent filings. This case ends not with a loophole or a clever escape, but with a harsh reminder that confidence without legality is just noise, and the law always has the final word.